Thank you, Mr. Speaker. I urge a yes vote on this amendment. Mr. Speaker, we need to consider very carefully when we prohibit parents from being able to access information about their children, especially their minor children. Mr. Speaker, this amendment clears up what may end up being a fatal flaw in the underlying bill. If the bill prohibits custodial parents from being able to find out what their own children are up to at school or what's being done to their own children at school, we are setting in place a problematic public policy. This is an important amendment to the overall aims of the underlying policy, Mr. Speaker. Vote yes to defend a parent's right to know what's going on with his or her own children. Thank you, Mr. Speaker. As we've heard in our earlier discussion on this bill, some of the definitions in the underlying bill are overbroad. Specifically and critically, the definition of what personal information that would be redacted or held back from the public is overbroad. So what this amendment does is it narrows that definition. It says that personal information which could be withheld from the public will include the student's address, last name, date of birth, phone number, personal phone number, email addresses and similar contact information, and any financial information specific to the student. So it narrows that definition of the exempted, in the language of the bill, or basically the information that could be held back from the public. Mr. Speaker, this is important because courts that would have to deal with these definitions in legal actions that will almost certainly follow from this underlying bill need guidance in what constitutes information that cannot be made public. In my own legislative district, about 15 years ago, there was a relevant court decision involving a school district in my area and a couple of kids who got in a fight on a school bus. And in that case, the court indicated that the images of the two kids fighting on the bus could be the kind of information that this overbroad policy would say must be held back, could not be made public. Now, Mr. Speaker, that I don't believe is the intent of the underlying bill. I believe the intent of the underlying bill is to protect a child's identity. But if a fight on a school bus, the video of that, could be included in the overbroad definition of personal information, then the underlying bill will do more harm than good to the kids of this state. So let's vote yes on this amendment, Mr. Speaker. Narrow the definition of that held back information in a common sense and reasonable way, protect the kid's identity, but make information that may be of more general import and use available as it should be. This underlying bill needs some common sense, Mr. Speaker. Vote yes and give the bill that common sense. Bad bill, vote no. Mr. Speaker, parents are the primary stakeholders in their children's upbringing. Not a school district, not a court, not any other interested party. Parents are the primary stakeholders in their children's upbringing. And what this Public Records Act bill does, in a small way, is it begins to erode that basic premise. Mr. Speaker, we cannot make public policy that will last very long or do very well if it's based on an assumption that abnormal behavior or abusive behavior or bad family situations are the norm. Mr. Speaker, this Public Records Act exemption does expand in an overbroad way that information with a nexus to the public interest from being able to be accessed by the public. Now, we do want to protect kids' identities. Of that, I don't think you will hear any disagreement. And we offered a mechanism for protecting a student's personal information. But this bill, like others we've seen, Mr. Speaker, goes too far. It's too broad. And in its overbreadth, it is undermining the primary stakeholders in children's upbringing, their parents. It's a bad bill, Mr. Speaker. Please vote no.